Good morning. The time is now 10:22, and I would like to reconvene this meeting. Welcome, everyone, and welcome to the viewing and listening public to this 25th public hearing of the Joint Select Committee on State Enterprises. My name is Anthony Vera, and I very much appreciate your attendance here today. The purpose of this meeting, of course, is to continue our examination of submissions and all other issues relevant to the operations and performance of CEPEP. The role of the committee is to aid CEPEP in improving its performance and operations, resulting in a more efficient and effective organization. This meeting is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. Viewers and listeners can participate by sending comments relating to today's engagement with the CEPEP via email to parl101@ttparliament.org or on our Facebook page at facebook.com/ttparliament or on Twitter @ttparliament. So welcome, officials of CEPEP, Hardy's Chartered Accountants, Ministry of Rural Development and Local Government, and the Ministry of Finance Investments Division. May I invite you to introduce yourselves?
Good morning, Mr. Chairman and members of the committee. My name is Ashton Ford. I'm chairman of CEPEP. You want me to introduce or do you allow them?
Can introduce themselves, thanks.
Morning to the chairman and members of the committee. My name is Keith Eddy. I'm the general manager of CEPEP Company Limited.
Good morning, members of the committee, listening and viewing public. I am Sarah Ramlogan, Acting Permanent Secretary, Ministry of Rural Development and Local Government. Thank you.
Yes, and good morning, Mr. Chairman and members of your committee. My name is Jamil Chidi Amiral, Acting Deputy Permanent Secretary, Ministry of Rural Development and Local Government.
Good morning, Mr. Chairman and members of the committee. My name is Nicole Gopal Singh, and I am the Corporate Secretary at the CEPEP Company Limited.
Good morning, Chairman, members of the committee. My name is Anil Brijlal, and I'm the Managing Director of Hardy's Chartered Accountants.
Good morning. I'm Jennifer Lachman, Deputy Permanent Secretary, Investments Division, Ministry of Finance.
Good morning. Ryan Maraj, Senior Business Analyst, Ministry of Finance, Investments Division.
Good morning. Lester Herbert, the Director of the Central Audit Committee, Investments Division.
Good morning, everyone. I'm Dewati Lalcha, the Senior Financial Officer at CEPEP.
Good morning. My name is Marilyn Michael. I'm the Deputy Chair of CEPEP Companies Limited.
Good morning, everyone. My name is Alicia Austin, Senior Internal Auditor at the CEPEP Company Limited.
Good morning, everyone. My name is Nilufa Ali, Accounting Executive 2, Ministry of Rural Development and Local Government.
Pleasant good morning to everyone. My name is Gaynal Andrews Vegas. I'm a Senior Planning Officer at the Ministry of Rural Development and Local Government.
Thank you, everyone. Before I ask my committee members to introduce themselves, let me just point out that Member Simonet has asked to be excused. Thank you. Member Mark?
Yes, good morning. Wade Mark, member.
Good morning, everyone. Sherry Ann Critchlow-Coburn, member.
Morning, everyone. Lester Henry, Vice Chair.
Morning, General Antoine, member.
Morning, Adrian Leons, member.
Yes, and Member Karim, I understand, is on his way. Just to remind everyone to put your cell phones on silent, and when you are speaking, to turn on the microphone, and after, to turn it off. Okay, Chairman Ford, would you like to make some brief opening remarks?
Thank you, Mr. Chairman. I would like to address some key areas today, which is attended to by the CPEP company, which we feel is very, very, very urgent. And I'm sure the national community will be keen to hear what we are doing about it. It involves the work undertaken by our 265 contractors, but I'll come back to that later. But what is paramount importance to the board at this time and management is some outstanding matters. One, outstanding, I'll put it in heading, outstanding management fees. We have 77 contractors, according to the records, who exited the company in 2018. And they are owed over $30 million in management fees. The reason for the non-payment is simple. They will not pay any NIS as required by law. In other words, they were non-compliant. The practice was carried out without any penalty from the last administration. What I am saying is, apparently between 2010 and 2016, this practice was going on where the contractors were not compliant and they were allowed to work and they got their management fees. When the new board came on board in 2016, that practice stopped. So the records we have is from 2016 to 2018. And once the contractors fulfill their statutory obligations and pay off the NIS that they owe, the management fees will be paid. And I made that point on the last occasion, how important it is, especially for the workers, because as you know, the workers are simple people, salt of the earth, working daily to keep the place clean. And if they don't get if the NIS is not paid up, they will not get the monthly stipend when they reach the age of 60. The other major issue we are faced with is what is being referred to as a health sector initiative. When the new board took office in 2016, they were greeted with an outstanding claim of $160,310,000 from contractors. Recall on the last occasion we indicated that this program had the blessings of the cabinet, the then cabinet. We had passed on that cabinet note to the committee. We also indicated that it was contrary to the company's mandate from its inception. However, in an effort to resolve this massive payout, the new board appointed a quantity surveyor to verify the claims made by the contractors. In the interim, some contractors sued the company for outstanding payment. And I have the list here of the contractors who sued, who took a legal action. The project had a very, very short lifespan, Mr. Chairman. That is from June 2015 to August 2015. I want to repeat that. $160 million were being claimed for projects undertaken, allegedly, between June 2015 to August 2015. Mr. Chairman and members of the committee, you'd be shocked and surprised when the QS presented his report. After it was assessed, it was a whopping $100 million less. In other words, some of the claims made by the contractors were drastically inflated. In fact, there is one example with the sub-judice. I'll just give you the example. One contractor did absolutely nothing, but made a claim of $3 million. This is very serious matters we are faced with. What we have started doing is some contractors who did not go to court are willing to negotiate and look at the quantity surveyor's report and perhaps come to a settlement because they did work. But the claims were a bit high. In some cases, the claims might have been lower. The QS report was higher. So, I'm sorry, the contractor claim was lower and the QS report was higher. The other big major problem we have is the unaccounted $21 million. The board received a letter dated the 23rd of January 2019 from the EMA, which confirmed that $21 million was released to CEPEP on the 27th of February 2014 by bank transfer OT 74-201-4678. The then board opened a separate account with the funds at First Citizen Bank here in Port of Spain. Since our discovery, and I'll put it as a discovery because it came about because a company was suing again. Since our discovery of that release, the information regarding the account, we are awaiting vital information from the bank as to the disbursement of the funds. The whole account was used up. All the $21 million was used up. We cannot find any records how the money was spent, who withdrew the funds, etc. The bank has promised to provide the necessary details. Another issue came up, the construction of box drains. Again, a deviation from the CEPEP mandate. A total of 85 contractors were awarded for the construction of box drains during the period 2012 to 2015 by CEPEP. It must be noted that half of the total amount of contracts awarded went to the penal DB areas, 41 to be exact. A total of $143 million was spent in that period. Maybe the auditor can provide information as to how the contracts were awarded. The contracts were awarded by tendering process. How did the company arrive at the decision to build box drains in those respective areas? Some other areas benefited, of course, but mostly in South. I have the list here. All the contracts that were awarded and the costs.
You'll make that list available to us?
Yes, of course. I thought
Thank
we
you.
had sent that to you. You should have that. The other issue came up was the outstanding payments to inland revenue. One of the major embarrassments we encountered was the outstanding sum of approximately $7 million owed to inland revenue for the period 2010 to 2015. The general manager will elaborate on that matter. Another area that was of concern to us, but it has stopped, is what was referred to as the marine or coastal contracts. Some contractors were paid $250,000 a month. I think there were about five. In fact, one of the contractors didn't even have a boat, but he was getting $250,000 a month. But despite all of this, you know, we continue to do our work. We have approved a number of policies, different policies. As we go along, we will inform the committee. I'm sure we have provided a list of what we have approved so far. The other major problem we encountered was the question of the external auditor.
Chairman, thank you. You have raised some very, very important matters here that I'm sure we will want to interrogate in depth. As you were just about to talk about the external auditor, I think that might be a good opportunity to segue, because you had talked about the period June to August 2015 with that $116 million issue. And the external auditor, Hardy's Chartered Accountants, resigned in the preparation of the financial statements year ended 30 September 2015. So I wonder if it might be a timely moment to hear from...
No, Mr. Chairman, I crave your indulgence. No. I have a problem with that. And I want you to hear me first before this gentleman speaks. Because internally, we attempted to settle that matter. The audit committee invited the external auditor to a meeting, and he refused to attend. And the Minister of Finance had sent a letter to me indicating that the chairman of the board must not get involved in audit and tendering matters.
Understood, Chair,
and we wanted to settle some. I have the matters here outstanding.
Chairman Ford, we asked for the auditor to be here today. The auditor under the Companies Act is required to be an independent, impartial voice. We are interested in hearing the auditor, and you will have an opportunity to reply.
Mr. Chairman, what the point I am making, and you're not listening. The point I am making is that the company attempted to deal with this matter. He don't want to deal with the matter unless I am present. So I'm here now, so he want to talk, but I will not take part in this meeting if that is the case. I will not take part because he is insisting and he has his own way. He wanted to control the board, and now he somehow or the other, he got involved and he's here so that he insists on having me present. I don't want to be present when he's something.
We don't want to preempt anyone. I think we are interested in hearing, and we can make our own determinations.
Well, Mr. Chairman, I am not, because this gentleman refused to meet with the audit committee. He insists on meeting with me. Now he has a chance to sit down next to me in front while my financial person is in the back. No, Mr. Chairman. This is wrong.
As you know, Chairman Ford, I have a very high regard for you. We go back many years, and I can certainly assure you that nothing will be allowed to take place here that would be in any way seen as a besmirchment against your personal good name and reputation. But this committee has a certain oversight function, and we are interested in hearing all aspects of the company.
One question, Mr. Chair. I don't want to interrupt you. One question. Why is it that he refused to meet with the audit committee to settle all these matters?
We will ask him that. We can start with that. So, Mr. Bridgelal, if you can answer Mr. Ford's question, and then
I will leave.
Be interested in hearing. Sir, it's your call, but I would really encourage you to stay.
Good morning again. When we resigned, as the auditors, there were 3 reasons. In summary, first one, there was restricted access and refusal by the company to supply pertinent information. That information had to do with the use of the going concern assumptions as to whether or not the company was doing the proper thing as far as looking at the going concern of the company. We requested information, we never got it. There was a refusal from the company to provide the information. The chairman made public statements against us, right? We did write to the chairman a few times, requesting meetings to deal with it. We never got any response. All that is detailed in our submissions to the committee. So the committee should have a detailed explanation as to all the steps we took in order to meet with the chairman and deal with the statements that the chairman made. Towards the end, there was a deliberate breakdown in the communication by the board of directors to us as the auditors. We tried everything to resolve these issues, and it reached an untenable position. We had no choice but to resign. The last meeting the chairman is speaking about there, in which we refused to, which he says we refused to attend, that really had to do with, they called us for a meeting after the chairman made his comments and after we tried to get some sort of explanation from him. And there's no way we could have gone about business as usual, dealing with the audit committee, right, when the chairman has made these public statements and it was been carried in all the newspapers and that sort of thing. That was so pertinent that it had to be done and dealt with before business could have continued as usual.
Thank you. May I just state for the record that Chairman Ford has absented himself from this meeting. I take it that the Deputy Chairman, Ms. Marilyn Mitchell, would be able to assist? Michael, sorry. Thank you. Questions?
Good morning again. I would like to ask, was there a submission besides, based on your letter of resignation, basically indicating breakdown between yourself and the board, was there an attempt to meet with the managing director or the CEO at that point in time?
Yes, on numerous occasions, we called. We was trying to get at least some sort of feedback. We got no response to our emails, no response to our calls, so we did try.
So the invitation to meet with your good selves would have been won by who?
Can you repeat that question, please?
Who would have invited you to meet?
You mean the final meeting?
Yes.
That would have been from the COPSEC.
And as a company that would have done work, didn't you see that as an opportunity to lodge your documents?
No, because the meeting was, we were invited to the meeting, and there was the expressed intention from CEPEP that they will not discuss the statements made by the chairman. And like I just previously explained, we reiterated, and we did say to the COPSEC that due to the severity and the intent in which these statements were made by the chairman, we had to resolve those issues first before we could have gone forward with dealing with the business of the audit.
So your refusal for the meeting was basically based on statements and not necessarily to deliver your service as they would have contracted you. Is that correct?
That is correct.
Okay.
I'm trying to get a sense as to what was the underlying problem. Is it because you were not getting information that you were asking for?
That is one of the reasons. On 10th of May, 2018, we sent a letter, and the title of the letter is The Audit of the Financial Statements, Management's Use of the Going Concern Assumptions in the Preparation of the Financial Statements. Now, what has happened was that the company displayed an inability to pay its creditors on the due dates. We saw from social media and everywhere else that there were legal proceedings against the company, which resulted in claims that the company could not have settled. There was a levy on the assets of the company. That now are the underlying conditions and factors that shows that the going concern of the company is in doubt. So we had to do additional auditing tests. So based on that, we sent a letter, we requested information, and we never received the information. Now that is very pertinent to the finalization of the audit. Without that, we could not have continued.
So if I recall, it's a legal requirement for a company to have an external auditor. Is that so?
It's not a legal requirement. But it is a requirement for the state enterprise.
Right. And what is the role of the external auditor?
Our role is to provide an opinion on the financial statements, which is prepared by the management and the directors. So our role in that is very simple. We do audit tests where we need to get reasonable assurance that the financial statements are as a whole true and fair, in simple terms.
Thank you. Member Leons.
Chairman, I'd just like to make a general comment. I would think that we don't question the accountants based on personal issues between himself and the chairman. I would like, however, that the information that he would have been contracted for be somehow submitted where we can assess and analyze what are some of the issues. I wouldn't like this hearing to turn out to be something personal between the accountants and the chairman.
No, thank you for that, Member Leonce. And absolutely, we agree. We are really interested in the finances, not really anything of an ad hominem basis.
Could I comment to that? It's nothing personal, first of all. And secondly, what we were contracted to do, right, was our audit objective. Our audit objective was to obtain reasonable assurance whether the financial statements as a whole were free from material misstatement and to issue an audit opinion on it. Because we did not get the information which was required, we cannot issue an opinion. And as such, we cannot comment or anything else on the audit of the financial statements. So there's no way without us issuing an audit opinion that we could comment or discuss anything else, because it all ties in. We need to look at the financial statements as a whole and give an opinion on that.
No, I understand that. I'm simply saying that you were requested for a meeting by the CorpSec, and I'm thinking that this should have been dealt with at that meeting. Instead, you stymied or you deliberately gave hindrance to your completion of your work because of something personal between yourself and the chairman. And I am saying that you would have been given an opportunity when the CorpSec, which I think is the right way of communicating to yourselves, to meet, to discuss these issues that would have allowed you to complete your professional contract, your arrangements. I don't want this chairman to be a to and fro. I just wanted to make that statement.
Thank you, Mr. Chairman. Mr. Bridgelal, in your letter of the 31st of October 2018, you indicated there has been an outright refusal by the management of the company to provide us with this pertinent information. Could you indicate what is the information and what do you mean by outright refusal?
The information we requested in detail had to do with the going concern assumption. We requested management's assessment of the company's ability to continue as a going concern. This assessment should include the management plan for future actions, cash flow forecasts, management's assessment of all legal proceedings against the company, management accounts for the year ended 30th September 2017, trial balance as at 30th September 2017, the aged accounts payable listing as at 30th September 2017. Most recent management accounts, trial balance, and aged accounts payable listing, access to all board minutes held by the Board of Directors for the period 1st of October 2015 to present, listing of all litigation and claims by creditors against the company, and the names and contact of the company's legal counsel and attorneys for each matter. We gave them a deadline of 3 weeks, and it was never presented to us.
I think for me, what I'm trying to get at is the outright refusal. There's a difference in outright refusal and a company's inability to provide the information.
Right.
And that is what I'm trying to get some sort of clarification on. And all of these items you would have listed, at what point in the audit were they requested, and is it normal to request all of this information that you would have requested?
I'll address the question first about the outright refusal. There was an outright refusal when we met, when we presented the letter. The company's management didn't think at the point in time that there was a going concern issue. Right. With respect to your question on whether this is a standard thing that we do, and we ask. When there's a going concern doubt, this is very standard. So this is something any other auditor, any other auditing firm would have applied and would have requested.
I'm understanding you to say you felt there was a going concern issue. The company did not think there was one. And I guess that is why they probably did not provide the documents. Were there further discussions to resolve that? And is it that the company at some point would have formally indicated they are not prepared to submit the documents? I'm just trying to get what really happened. Because I am not getting that it was formal, as auditors, you will formally refuse the documents. I guess later on we could probably ask the managing director.
Right. Attached to that, to the submission we made to the committee, there's a letter we sent on the 21st of August, 2018. On that letter, point 9, we can start there. On 16 February 2018, we learned via social media and of a levy on the assets of the company by a contractor. This was later confirmed by the traditional news agencies. Thursday, 6 April 2018, I instructed my secretary to call for the general manager, Mr. Eddy. She did not get through with him, but left a message for him to return my call. He did not call back. Monday, 9 April 2018, I again instructed my secretary to call for the general manager. His secretary said he was in a meeting, and my secretary left a message requesting he return my call. He did not return my call. Thursday, 12th of April, 2018, I again instructed my secretary to call for the general manager. She was transferred to his extension, but he did not answer. Thursday, 12th, 2018, I sent an email to the general manager requesting that he call me. I got no response or acknowledgement of the email. Tuesday, 24th April 2018, I sent an email to the general manager requesting a meeting with the board to discuss the issue of the going concern of the company in light of the levy of the assets of the company and the disclosure of other pending litigation matters by the chairman in the public domain. Again, I received no response or acknowledgement of my email. Tuesday, 1st of May 2018, the COPSEC, Ms. Nicole Gopal-Singh, called. She said she's responding to a request to meet. She said the chairman of the audit committee, Mr. Rick Cooper, cannot meet as he was leaving the country and was not sure how many weeks he will be away. She suggested a conference call with Mr. Cooper on Friday, 4th May 2018. We agreed. Friday, 4th May 2018, I spoke to Mr. Cooper, and I explained my concerns with regards to the going concern issue of the company in light of the levy by the contractor. I also informed him that we require additional information in order to ascertain the going concern position of the company.
We have the letters, thank you.
Right, I was just, yes.
Yeah. You have a question?
I will ask, I think I would want to address certain questions to the general manager after.
I believe Member Antoine? Yes. Okay, so thank you very much. We would now like to hear from the company, whether general manager or deputy chairman.
Good morning to you, Chairman, again, and members. Let me just first start by, and I don't want to get into the personal issues and all of that, but let me just first start by saying, please bear in mind that this was a 2015 audit where none of the present board or management was there at the time. The issue that came about was, and we've spoken about it here at the committee, was that there was information that was lost with the server crash. Neither the management nor the board could verify any of the information that was presented in the audit. That was clearly stated from the very beginning. And that was the main basis for us going back and forth with the auditor. There was a lot of conversations back and forth. There was an audit committee with a chairman. There was a finance manager that was in constant contact with us. So all of these days that he just responded to and called actually predates any of the requests that he's referring to. So I don't know the significance of this. The auditor was in constant contact with our audit committee, chairman, committee, as well as the finance manager. There were a number of issues. As a matter of fact, the issue of the going concern, when it was raised, was responded to by the finance manager, and I have emails to the effect. We indicated, and had nothing to do with the fact that this going concern, because it was indicated to the auditor that this was a company that just received $122 million in the mid-year review. And our only reason for the levy was that we were ensuring that we did not just go and spend government money and pay out $160 million. The chairman talked this morning about what it actually came up to in terms of work that was done. So I'm very happy that we took the stance that we did in terms of being able to take the matters to the court, as well as get a quantity surveyor to be able to deal with those matters. So I really don't want to go back and forth. We did provide the auditor with quite a bit of information, even withstanding that, as I said, that none of us were there at the time. So our main reason for some of the questions, and I'm not an auditor, but there were quite a bit of, as I understand it from my finance manager at the time, there were some ML points that came from 2012, between 2012 and 2020, which is even worse. And this board and management was actually asked to support information for that. So there were a number of issues that came up with the auditor. There was a very cordial relationship until the very end, and we felt at the end, and he stated, you know, he was called to a meeting with the relevant individuals that was handling the audit, which was the committee, the chairman, and the finance people, as well as the general manager, and he refused to attend. So at the end of the day, the resignation, we didn't get rid of the auditor resigned. So I'm not, you know, I mean, I'm not sure why. There's a lot of back and forth and a lot of information, and however you hear it here, it'll probably be one side. So I just heard one side. I'm a little bit shocked at some of the things that I've heard. But I could tell you very clearly what our reasoning were as a management, and I was not prepared. The chairman of the audit committee was not prepared, and the chairman of the was not prepared to sign on to something that we could not verify the figures. And that was our only beef. We wanted to be able to verify the figures. And we had to be able to rebuild the information that was lost. First of all, we talked here about finding the information, and eventually we were able to recover it. We are still in the process of trying to rebuild that information. And that was our main reason.
Well, thank you, and thank you for reminding us that at that time, none of you present were on the board. But it is a little discomforting and perhaps a little unfortunate that you all were not able to work more closely together, because the auditor has a particular role to play. The auditor does require to have the necessary resources and access to information that will enable him to fulfill his mandate. And where, as you have indicated, there was this computer crash and there was a real difficulty in being able to put together the information, one might have thought that you could have worked together to address that particular circumstance. Remember, the auditor provides cooperation sole, as well as the directors, with accurate financial statements. And he serves as an independent and objective party to monitor the company's financial circumstances. Members, questions?
I would like, good morning. Mr. Chairman, I would like to put on the record, as a member of this committee, my complete shock and disappointment at the disrespect and contempt shown towards this committee by the chairman of CEPEP. I want to make that as my personal view. I want to record that. I want to also say the following. And I'm asking Mr. Anil Bridgelal. We have to be very blunt and frank here. Hardy's produced accounts which were approved in 2012, in 2013, in 2014. According to correspondence you have circulated and we have in our possession, you had completed your fieldwork for the accounts of 2015. All you were waiting on were signatures from the manager. In fact, I have a paragraph that says in your correspondence that there was agreement with the accounts of 2015, both from Ms. Judy David and Mr. Keith Eddy. The accounts were agreed upon. However, we requested the management representation letter and director's representation letter be signed. What I want to ask is that if all this fieldwork was done, the accounts were agreed upon by Mr. Eddy and Ms. David, what would have prompted this new development where we are being told, and up to now I have no evidence, no information, this committee has no evidence, no information on this so-called crash of the computer. And I would like to know whether you as the accountant, the external auditor, can you explain to this committee why the accounts were not completed in 2015, even though all the field work was done, even though it was agreed upon, but they were not signed off? And what has happened to the accounts for 2016 and 2017, since you only resigned in October or thereabout of 2018? Could you share with this committee these, at least clarify these matters? And could you share with us this request for backup information that was made to you by CEPEP when they indicated to this committee that there was a computer crash on the server crashed, and they asked you for possible backup information? Could you clear the air on these matters for us?
Firstly, we didn't produce the accounts. We didn't compile it. That is the responsibility of the board and management. We as the auditors, we audit the financial statements, right? And I think that's something that everybody needs to get clear, that we are not responsible for the preparation and presentation of it. We are just there to give an opinion on it. Right? Even though the field work was completed and there was a meeting and it was approved between the auditors and the management, two months after that meeting, in February the following year, before the accounts could have been finalized, that is when there was a levy on the assets of the company. By that instance and that situation, that casted a going concern doubt on the operations of the company. At that point in time, we had to do additional audit work to satisfy ourselves that the company is not a going concern risk. And that is why we ask for all this information. Now, they did say, well, the company has gotten a subvention from the government and everything else. We have no problem with that. It should have been done as an assessment. It should have done through the proper channels, through the proper way. And we would have listened and we would have worked with them. But there was a refusal to give us this information, other than the conversation that we got a subvention from the government. The backup information, that's not our responsibility. It is the responsibility of the directors and the management to safeguard all the assets of the company. What we do, we audit the financial statements. It is not our responsibility to keep a backup of their general ledger. It is a very long ledger. Think about every transaction that a company does, right? We do not go through every transaction. We look at reasonable assurance, not absolute. So we test.
So from what I'm hearing is, when the levy took place, you became very concerned that the company was technically insolvent and still continuing to trade and do business.
It was not technically insolvent. They could not have met their debts. So like every other company, you reach that position, you must have a plan. What we asked for, what was the plan.
Right. And may I now inquire from the officials at the Ministry of Finance Investments Division, at what point, or did you become aware of the auditor's concerns?
Thank you, Chairman. It was sometime in October 2018 that the auditor, the external auditor wrote the chairman and copied the Ministry of Finance. I don't have a letter here, but he indicated his reasons for resigning from the audit engagement.
Yeah.
No,
Okay, go ahead.
Yeah, I'm being confused by the timeline here. This audit that you were contracted to do was up to September 2015. What does this have to do with the levy in 2018?
When you're doing the audits of a company, right, you have to look at what we call subsequent events and events after the balance sheet date. We need to sign off these accounts sometime after the year end of the company. So there are auditing standards which we must follow, where we have to look at whether or not the company is a going concern, whether there were events that would have affected the company going forward. There's a lot of stuff. So we have to look at that and any factor up until the point in time in which we sign the audit report, and the board of directors also sign the audit report. It's a standard international auditing standards.
And you are not of the opinion that you are exceeding your mandate?
No,
for
definitely
audit
not.
of 2015
Definitely
in
not.
2018?
Definitely not.
Question, please. Okay, the accounts were agreed upon in October 2017. If they had been signed on that date, that would have been it, would have been finished. Is that correct?
If we did get the representation letters by management and by the directors, yes, it would have been signed.
Did you ever get those representation letters?
No.
Why not? No, because I am a little bit confused. Let me just indicate. The accounts were agreed upon in October 2017. In February, the auditors would have learned via social media that there was a levy on one contractor. And based on the levy on one contractor, suddenly all the work that would have been done on all the accounts became almost null and void. Bear with me, I'm not an accountant. I'm just looking at it from a common sense point of view on what I'm reading. So it is suggesting to me that something more than what is presented in the paper here may have happened, because if it's just what is presented here, it makes very little sense for the accounts to not have been signed off, because the auditors could have signed off on the accounts and put an explanation of whatever concern they had in that document. And that is what I'm thinking. Maybe the people from the Ministry of Finance could then help us after you respond. Please, thank you.
It doesn't work like that. When the accounts were approved with the auditors and management, it has to go to the board. So we gave them enough time for it to go to the board. Remember, you have board meeting once a month. While we were waiting on the feedback from the management, that is when the levy happened. Now, whether it's one contractor, whether it's 10, it showed that the company, to us, and to any other reasonable auditor, they could not have met their debts. That is what casted doubt on the going concern of the company, and it was more than enough for us to start requesting information with regards to the going concern. It did not put everything else before as null and void. It was a new condition that came on in which we had to do additional auditing work before the accounts were finalized.
Member Mark, you had a question? And then.
I just complete. Okay, so you said they had to give this information. Is it that once a company did not give you that information, you would have resigned from any other company once that wasn't provided? I'm trying to get an understanding, because I've been in organization before where the auditors would have done their sign-off and they would have indicated what the areas of concern were, as apart from just after having done all that work, all the years have elapsed and there been no audit, no financial statement that would have been audited. So I'm just trying to get an understanding of that.
With any other company, we could have completed the audit without that and issued a modified report. But like I said in my resignation letter, there were 3 issues, right? One was the lack of information concerning the going concern. The other one, which was very pertinent, and which we had to deal with, which was an outright refusal from the chairman to even deal with us, was the public statements he made on a press conference which was held on Tuesday, July 26, 2018, where he said the external auditors, Hardy's, has been considered by us as hostile. We are trying to work out a mechanism to move him and bring in external auditors as we can get to truth on the bottom of all this. Instead, we are trying to find a way to remove the external auditor and get an objective person. The external auditor is very hostile. The auditor is not carrying out his duty to bring this up. Now, when you have a client and the chairman of the board is making these statements in public, right? These are issues that has to be resolved before the audit could continue. We cannot have a client making these type of statements in public about the auditor, right, and not deal with it.
I think we got the point. You said there was a third issue?
Yeah, the third issue was the breakdown towards the end with communication with management.
Mr. Chairman, it is a lot clearer because I understand now that clearly the main thing was the comments of the chairman and the auditors, the way they received it. Because other than that, the account itself, it was not making sense. So I understand now that the bigger issue was that issue with the chairman and the statements made. So I am okay now.
It seems like a breakdown in the personal relationship. Yeah, yeah. Bakarim.
Yeah. I just want to follow up briefly, Mr. Chairman. Was it a breakdown in personal relations or was it something more than that? We are hearing about this computer crash. And I'm asking myself the question, because we have another matter to deal with in a short while. Is it a personal difference between the managing director of Hardy's and the chairman of the board of CEPEP? Because you see, I wouldn't like to leave this meeting and come to the conclusion that it was purely personal. Because it seems to me, in reading what I have read, it is something more deep than personal. And that is why I agree with my colleague. We need to get to the truth of this, because we are not getting, from where I sit, the real story. What caused this development all of a sudden? Because Hardy's had been there for several years, and you were producing reports on a regular basis. There was a change of administration, and immediately thereafter, there appears to be some challenges. And could you share with us whether it was purely personal? Was it political? Was it deeper? What was the reason for this breakdown in communication between your company and the CEPEP company? What was the reason?
We have always had a very good relationship with the management and directors of CEPEP. Even as the administration changed, we had a good relationship with Mr. Lynch, who was there as the chairman, up until the comments by the Chairman Ford. I thought we had a good relationship with Mr. Eddy, with Ms. David, we were communicating, right? Today is the first day that I'm actually in the same room, or was in the same room with Mr. Ford. I have never spoken to Mr. Ford. I've had no communication with Mr. Ford other than the letters which I sent, which he never replied to. So when, at that press conference, when he made those comments, it came as a total shock to me. I have never met Mr. Ford. I have no relationship with Ford. I have no idea why those comments were made. So that is why, as the auditors, we needed to talk with him directly rather than go through any conduit or any employees.
the Deputy Permanent Secretary, Mrs. Lachman. Given all that took place between these parties, can you advise whether any formal report was made to Corporation Seoul? Or maybe I could also ask the Ministry of Rural and Local Government on this situation that impacted on the operations of this organization. Was there any formal report coming from, let's say, Hardee's to you, or CEPEP to you, Corporation Seoul? And then I'll ask the Permanent Secretary whether they got any formal reports on this breakdown.
Member Mark, through you, Chair, there was no report done. The external auditor has no obligation to report any matter to the Ministry of Finances, Minister of Finances Corporation Seoul. The board would have engaged the external auditor, and therefore the communication would have been initially, and I'm hearing that he would have engaged the audit committee. I heard he spoke with the chairman of the audit committee, which the external auditor is required to do. But to say that there was any formal report from the company, no.
What about local government permanent secretary?
I'd also like to report that there was no report made to the Ministry of Rural Development and Local Government on this matter.
Okay.
Oh, thank you very much, Mr. Chairman. Since the chairman indicated whether I'm asking questions on this matter, I will now state this matter. Is it normal for Corporation Seoul, Ministry of Finance, and the line ministry to not know about an incident like this? And if you did not know, as you were saying that you were unaware, who would you think it will be incumbent upon to ensure that you are made aware of this matter? And thirdly, if you're made aware, what would you have done about it?
Okay. Normally, we would receive board minutes from the entity. We are supposed to receive signed board minutes from CEPEP, and if I would assume that the audit committee would have raised their concerns, or the board would have spoken about it at their meeting and recorded it in the minutes of the meeting, and in our review of the minutes, we would have picked up on that. And
Really is also, just not to interrupt you too much, when you all get these minutes, do you go through them, and would you have noticed, or was it not written into the minutes?
we would normally go through all the board minutes, and a report is done for each board minute. Anything that needs to be escalated to the Minister of Finance is done. Any issues that we pick up, we would write the line ministry and the company on it, probably for explanations.
So based on your perusal of the board minutes, did you see, notice, or identify any such matter that would have been drawn to your attention and for subsequent action?
We have a little issue at the moment where we received unsigned board minutes from CEPEP, and we have asked them to provide signed minutes because, as you know, we can't, like assume the bona fides of the minutes unless they are signed. So therefore, we cannot review until they are signed.
How long now have you been noticing or seeing or receiving unsigned minutes?
We wrote to the company in March of this year, and we from April 2018 to September 2018, we received unsigned minutes, and well, thereafter we haven't received any minutes from them. I would ask my colleague, Mr. Maraj, to tell us whether it was highlighted in any of the minutes.
Say something. I mean, I need to defend the company here. We did write to the Ministry of Finance. We did write to our line ministry. As a matter of fact, we held a meeting with the Ministry of Finance to discuss this very same matter. And we did write to the ministry to ask for advice on how to move forward. So I cannot sit here and listen to my colleagues saying that we did not inform them. There are letters that went. I was present at a meeting at the ministry where we discussed this matter and we asked for advice on the way forward. And we actually did receive some correspondence from the ministry.
Thank you for that. I was going to ask you to.
What do you say? I mean, there's so many things I'm hearing here this morning that just not adding up.
What about the Ministry of Local Government?
Sorry?
What about, you had...
Yeah, we always keep our line ministry informed.
No, they were informed in writing as well?
Yes.
You had a meeting with the Ministry of Local Government?
No, I met with the Ministry of Finance.
No, I'm asking whether your line ministry is the Ministry of Rural Development and Local Government.
Yes.
Did you, in terms of the protocol relationships, did you advise them first and foremost in writing or auditorily so?
And probably more than likely in writing. You're asking me to remember a lot of things, but more than likely in writing, because once we write to the Ministry of Finance, we will CC our line ministry.
Was there a meeting as a result of that causation?
There was a meeting with the Ministry of Finance.
No, was there one with your line ministry?
No, there was not a meeting with
and
the
why
ministry.
was there none?
Because of the issue of audit, we were dealing with the Ministry of Finance and we needed some advice on how to move forward.
But certainly I was a CEO for many years. My line ministry must know about these situations and must take action.
But I just indicated that the line ministry was informed.
No, I'm saying that the question I was really asking, let me see if I can ask it again in a simpler way. Why was there no communication, meeting or otherwise, on a significant and important matter like this with your line ministry?
But I just answered your question. You were saying there was no communication. Communication could be a meeting. Communication could be in writing, and there was writing.
Was there a meeting?
I just indicated that there was
no meeting. Well, could the ministry representative tell us, if the general manager is saying that there was communication, why was a meeting not caused to be held on a critically important matter to the taxpayers of this country involving hundreds of millions?
Member, through the chair, with due respect to Mr. Eddy, I would really like to request a copy of that memo that may have come to us, because I'm sure if that did come to the ministry, we would have requested discussion on that matter. So when we do, maybe he did send it and we have not received it, I cannot say. But if we do get a copy, we would be able to address the matter. Thank you. And on the other question you asked with respect to the board minutes, we did write the company February 4, 2019, asking for four items: the up-to-date strategic plan, the administrative reports 2016-2017, all outstanding financial reports, and board minutes from April 2018 to December 2018. We have not received those minutes today.
Just one quick question. But this is a very serious thing. Because, I mean, I recall even as a minister, a former minister, there was a statutory time limit by which time an administrative report is supposed to be sent in.
But those minutes were sent.
No, I was asking about the administrative report.
The administrative reports were sent because we sent administrative report up to 15, 16, I believe, and we are currently finishing 16, 17, and 17, 18.
Okay.
I mean, I'm not understanding what is happening here.
Okay, well, I was just really clarifying the relationship and the subsequent causation of information that will flow from the line ministry. But the question I'm also going to is, were any of this matter with respect to the external auditor, was this placed into the record? Because the administrative report will normally be laid to the cabinet.
Was this indicated in any administrative report subsequent to this incident?
It's before. If it was, it would have been before our time. So it probably would not have been, because there was 15, 16 was not done by us, 16, 17 was not done by us. And if you look at the dates of these matters, it was after that period.
And again, because we are oversight of state enterprises, and the question has to do with external auditors, I just want to remind the company that under the Companies Act at Section 173, the auditors have certain rights. Section 173 of the Act empowers the auditor of a company to require the present or former directors, officers, employees, or agents of the company to furnish to him such information and explanations and such access to records, documents, books, accounts, and vouchers of the company as are, in the opinion of the auditor, necessary to enable him to make his examination and report. And there is also a corresponding statutory duty on the directors of the company to obtain the required information and explanations from the parties concerned, which can reasonably be obtained and furnished, and to furnish same to the auditor. So it seems to me that somewhere along the line the ball was dropped, and that is a real worry and concern to this committee.
Chairman, let me just indicate that the company, and Mr. Bijal said it at the very beginning, there was never any issue between the management and Mr. Bijal, and documents were provided. The only document I can recall that would not have been provided would have been the board minutes, and that's where the board made a decision not to provide it. Management accounts, I mean, Mr. Bijal was liaising with the then finance manager on a constant basis, and I'm really sorry, because the chairman of the audit committee at the time and the finance manager at the time is not here. And all of these issues were taken care of. There was a lot of communication, and this agreement, I clearly remember that part in terms of the management letters, and I know the finance manager was going back and forth with the auditor to get the wording right so that we could sign off. And the auditor, at the point in time, they could not come to an agreement. So this issue about management agreeing, I cannot agree to sign. I said it at the very beginning. If I am unaware, the information is not there for me, I can't verify. My finance manager is telling me we can't sign off on these things, and I'm not signing off on it. So there was never any hostility. They were working together, and we could not come to agreement. That letter went, as I recall, it went back to the auditor. She made some changes. It went back to the auditor. There was disagreement. So we never agreed finally that this thing could be signed off because the wording was not right in that letter. So, you know, we have done, I think, as a company, what we needed to do to make sure that we were signing off on something that we could defend, and that's what we are there for. We couldn't sign off on this information as a company's right. The auditor takes samples. We needed to be sure that that information from 2015 was current and proper, and we could not do that because of the server crash. And this is not no fiction server crash. This is something that happened. We are actually trying to rebuild that information as we speak.
Thank you. I think we need to move on, but before we do, does anyone from the officials from the ministries have anything else to add on this point, and then we move on?
If I may, Chair, with regard to the going concern, there are, I'm speaking in general terms and for the information of the committee, there are some state enterprises that have similar issues, and they have written to Investment Division, Ministry of Finance, stating the concerns of the auditors and requesting certain letters from the Ministry of Finance, which the Ministry of Finance has facilitated. So this issue, I mean, you know, CEPEP has its unique issues, but is an issue that's faced by other state agencies. Okay, with respect to the resignation of an auditor may resign, an external auditor may resign if the auditor feels that the reputational risk is high. The auditor, under their auditing standards, can resign if he feels that way. With regard to the letter of representation, the management of the company is required to present a representation that all the information and explanations provided by management are true and correct. And the auditor also requires that. So that's just for the information of the committee.
I'm going to allow one more question from Member Critchlow, and then we're going to move on.
It's a short question, and it's just for clarification for me. It may help the other members of the committee. CEPEP is a state enterprise. Funds is from the government. Is it that the auditors had a concern with respect to the government's ability to pay? And it's of even greater concern because they would have indicated they got an injection of 122 million, but the auditors still had the concern. So my question is it that there was a concern of the government's ability to pay and support CEPEP going forward? And if that is what would have impacted their decision?
No. The concern we had was that the information that we required management to provide to show that the company is not a going concern was not provided. Yes, they said they would give a thing, but there were other issues. We had no problem if, like what the Deputy Secretary would say, that they would provide a letter. That would add to the information. Ministry of Finance would provide a letter saying, okay, this is the amount of money that's coming in. Management now would do a proper assessment and say, okay, this money comes in, this is how we will settle the claims. We requested the legal opinions of their lawyers with respect to each claim. We would take all that and we would make an assessment and say, okay, management is right or management is wrong in providing and saying that yes or no, the company is a going concern or not. And it never reached to that point. There was just an outright refusal from the beginning.
Well, Chairman, and let me respond to that. Actually, that was even discussed. Basically, we said, if you're saying that this issue of going concern, you're basically saying that the government is in bankruptcy, that they can't pay. So those issues were discussed and raised. We even asked the auditor for the working papers so that we can then get better comfort, and that was refused.
No, I think I would like to move on now. Member Mark, you have a question.
Yeah, Mr. Chairman. Mr. Eddy, may I ask, how long have you been working at CEPEP?
Since July of 2016.
How long can the permanent secretary indicate when was the board of directors appointed under Mr. Ashton Ford?
Member, I'll answer. It was 2017.
It was 2017?
2017. And Mr. Ford himself was appointed in 2018.
2018?
Yes.
Can you shed light on a matter that is before this committee? I call it the $1 million question mark. It's a $1 million question. It deals with an agreement between a former manager, CEO, I won't call the person's name at this time, and this company called CEPEP. This CEO apparently worked for just about 1 year with this company, and he was given $1 million in gratuity payments. I do not know what kind of salary Mr. Eddy, this gentleman, was working for, but he was the former CEO. But what I found very interesting and bordering on almost, it requires an investigation, is that it says that the CEO covenants that he will not at any time disclose to any person any confidential information about CEPEP and the terms of this agreement. Mr. Chairman, if someone has served his or her time and the person is leaving the company and the person is entitled to X amount of dollars, the person is given that money and he signs off. But this kind of agreement that I have seen here has raised some red flags. And I would like, I don't know if you, Mr. Eddy, or you like to indicate the corporate secretary, or the permanent secretary, or the Ministry of Finance, who could explain to this committee these terms and the basis for these terms, and whether the permanent secretary is $1 million, whether the permanent secretary in the Ministry of Local and Rural Government was aware, whether the Ministry of Finance, Corporation Sole, was aware, and whether they got approval for this agreement before it was signed off, or whether this was an internal arrangement between CEPEP and the former CEO of this company. Could someone clarify for this committee how this thing was executed, why, etc., and whether these agencies were informed?
Member, I could only attempt, because again, it predated my coming into the company. This would have been the last CEO, and it would have been done under the chairman at that time. So just like you, we did find the letter, and we saw what the payout was, and it raised some questions in our minds, but there's nobody here that would have any idea as to what took place. I could only assume that maybe the CEO at the time would have had a contract, because I think this was done in 2016, was it?
Yes, 16, yes.
So maybe he had a contract, and at the time, it may have been a 2 or 3 year contract, because I can't see that just being gratuity payment. There must have been some payoff for the contract or something, but the letter is... It didn't. Okay, so then my corpsec is now saying the contract didn't cater for a payoff. So I am unsure as to exactly, like you, what would have caused the letter that is in front of you and the payoff that was had.
So am I to understand that a former CEO was paid a gratuity of $1 million, but you don't have a copy of his contract of employment?
No, we do have a copy. That's why the corpsec corrected me and said that it didn't allow for
because Senator
yes.
Mark, Member Mark was trying to inquire what was the compensation package of that former CEO and how was the gratuity calculated?
We can provide the contract, the CEO's contract and the terms and conditions. I'm not sure if it will shed any light on your question, Member, but we certainly can provide that to you.
But in a matter like this, Mr. Chairman, would not the Ministry of Finance, given the quantum that is involved and the period of time that the CEO would have served for a year, would not a matter like this require some discussion or at least some communication from the CEPEP board to the management? Because this was a decision taken by the board of CEPEP. And that would have been in the minutes that would have been transported to the Ministry of Finance, Corporation Sole. Can I ask the Deputy Permanent Secretary whether you can help this committee in understanding whether such minutes were brought to your attention involving this quantum?
Through you, Chair, Member Mark, I don't have that information at this point, and certainly we would write the committee to indicate whether that was recorded in the minutes and whether any communication was sent to Ministry of Finance. However, I must say that the remuneration package of the CEO should be approved by the HRAC, and the contract of employment should have what the gratuity is supposed to be. So I am not certain whether that sum or those terms were actually in the contractual agreement between the CEO, well, the CEO's contract, sorry.
But would a sum of $1 million as a gratuity strike you as normal?
Definitely not normal.
And
Sorry.
And is it typical in a contract of this nature to put in a gag with these types of non-disclosure provisions?
I have not seen any in my stint at the Ministry of Finance.
Well, can we ask through the chairman to Mrs. Ramlogan whether you can also provide us or hint us whether you have minutes verifying this payment and whether this kind of secret arrangement where you are told do not reveal any confidential information, is that something that is familiar with signing off for such a arrangement, gratuity payment?
Member Ma, through Chair, I'm not aware of any contract termination clause with respect to disclosure in the ministry thus far. And with respect to if we were aware of that settlement package, I, like my colleague, would have to do some research with the board minutes to find out if there was such information shared with the ministry. That matter predated my... Yeah.
Would it be possible for us to get a copy of those relevant board minutes?
Yes, of course.
Mr. Chairman, I just have one before you release me. I want to deal with an investigation report involving Western Rawlings. Can I ask whether, well, first of all, what are the credentials of one Mr. Leonard Charles? I have him down as an investigator. Can someone, Mr. Eddy, may you be of assistance to this committee? First of all, by helping us to understand the credentials of this gentleman in question, his qualification and fitness for this particular assignment. And also, we understand from the material that CEPEP at the material point in time had 4 vehicles in their possession. However, it appears from the material before us, Mr. Rawlings was assigned one of those 4 vehicles. Can you clarify for us whether this, what I'm saying, is true rather, that there were only 4 vehicles at the material point in time owned by CEPEP, and that Mr. Weston Rawlings was assigned one of those 4 vehicles? So it's a 2-part question, and give us also the credentials and qualifications of the investigator, Mr. Leonard S. Charles.
Member, Mr. Charles is an ex-police, a member of the fraud squad. I can give you a copy of his CV that will detail his experience. He also has a company that does investigations. On your next question about the 4 vehicles at the time, those 4 vehicles that we refer to would be 4 vehicles for the position of regional coordinator, which is one of the positions that requires a vehicle. And Mr. Rawlings is a regional coordinator, so hence one of those vehicles would be assigned to him for his duties. And the way the assignment works is that you use the company vehicle for work, and when it's done, it's either parked up at the compound or it's parked up at a police station or a corporation or something of that nature.
Yeah, and Mr. Chairman, can I ask through you to Mr. Eddy, how was this gentleman selected, Mr. Leonard Charles? Was it on a sole select basis? how did he come about being assigned responsibility as sole investigator? Was that on the discretion of the board, or did you have a series of persons?
Actually, he is on the company's, he has a retainer with the company for investigating any of the matters that we have, be it in some of the hotspot areas, be it when contractors have any issues with windscreens, any of those type of matters when employees are threatened, anything that deals with that investigator, that is the company's external investigator that handles those matters.
But how long has he been assigned this responsibility?
Approximately a year.
But how was he selected to be retained by the company to deal with all these matters? Was it on a sole select basis?
I believe it was on a sole select basis. I don't think. Okay. Actually, not sole select. There was another person that was looked at, and then a decision was made to choose Mr. Prescott as the investigator.
Can you provide this committee with the whatever? Yeah. Can you provide this committee with the material, minutes, documentation, as it relates to how this investigator eventually was selected? Because you must have gone through a process. There must be material information available to the board of CEPEP, which you can make available to our secretary in writing, so this committee will be better apprised of how this exercise was executed. Thank you.
Mr. Leons.
Thank you, Mr. Chairman. I'd like to ask a question based on the chairman's opening remarks. He spoke about outstanding funds to contractors. One of these statements he made concerned me, where workers were not paid their NIS, and as such, due to the breaching contract, some of the contractors were not paid. Is there any way that the CEPEP could intervene to ensure these workers have paid their NIS?
Very good question. Actually, it does affect when the contractors, because we actually pay the contractors the monies to remit NIS and health surcharge. So when it's not done, it means that the worker suffers at the end of the day. In my coming into the company, we would have stopped the practice of, we started the practice of withholding management fees to force the contractor to continue. But some of the sums were so large that they could not, and some of them have exited the program. So what we are currently looking at is whether or not, and in quite a few instances, the sums owed to contractors for management fees is either is more than what is owed to NIS payments in some instances. So, and in some instances, so we are looking at requesting that the contractors write to us, indicate that we can actually use the fees that are outstanding to clear off the outstanding monies that is owed to the NIB and to the health surcharge. And if there's a surplus, it could then be paid to the contractors. Because that way we would fix the issue of workers being able to get their benefits. If it's left as is, then those workers will not, because in some instances, I don't believe those contractors will be able to raise the sums to actually pay it off. So it is a big concern for us that we are looking at.
But isn't it a breach of the law to collect money for NIS and not pay? And in which event wouldn't the company have reported it to the NIB?
We actually have reported it today. I mean, we sent all the names of the contractors that are in breach.
Thank you. Where are we with that? Have the contractors responded?
Actually, currently, what we are doing is we're writing to the NIB to verify the amounts that is outstanding. Once that is done, then we would send letters to the contractors and see whether they've responded in order to be able to, for us to be able to go forward.
Sorry, Chair.
And can you provide us with copies of those letters to the NIB?
Certainly.
You have anticipated time of when that process may be?
Ideally, with the company is hoping that we can actually get these matters cleared maybe in the next 2 to 3 months.
One other question. With respect to the outstanding amounts for contractors, I understand the chairman would have said some of the contractors would have choose to go to court.
Yes.
And some didn't.
Yes.
The payments for the undisputed amounts, were these amounts communicated to the contractors?
It's actually in current process. Some contractors were actually, 1 or 2 contractors who already agreed on to take the quantity surveyors amount, and we are now negotiating with all court as well as out of court to be able to clear off these matters, because as the chairman indicated, there would be significant savings for the government of Trinidad and Tobago if there's $100 million that could be saved.
I'm happy to know that you are at least initiating payment for the undisputed amounts, and then you could move forward with the balance.
Thank you, Member.
Thank you very much.
Member Henry.
Morning, everyone. My question is just for some clarification from Mr. Bridgell. How long have you been, at what point did you start being the auditor for the external auditor for CEPEP?
We were appointed to audit the financial statements from the year ended 30th September 2012, then 2013, and then 2014.
Okay. Do you have a contract, or is it a...
Yes, we do. We have what is called a letter of engagement. Yeah.
And that letter has a specific time frame? You were appointed for 2 years, 1 year?
No. At the beginning, we were appointed at every AGM. Corporation Sole passes a shareholders resolution where they appoint the auditor for the next financial period. After that appointment and that resolution, we issue what is called an engagement letter, which is a contract. So there is a contract for the audit of the year ended 30th September 2015.
Oh, okay. So there's no so every year your contract has to be renewed at the AGM, basically. Then.
Well, we reappointed at the AGM. Yes.
Yeah, reappointed.
Yes.
Okay. And what would, if CEPEP had a disagreement with you over any issue, it doesn't matter, what would the consequences of them terminating your services? Would there be any?
It would depend on the issue.
No, well, of course. I mean, specifically, let me get specifically then and say, if there's a disagreement like the one that arose, where they didn't think there should be any concern as your concern with them as an ongoing concern.
Right.
Because did you have any issue with CEPEP before that?
No.
Before, as an ongoing concern?
No.
Okay. So what was particular about that incident that triggered the ongoing concern?
We went through it already. The 3 issues in which why we resigned.
Mm-hmm. No, but I mean, there are other issues of outstanding monies, of outstanding claims, and so on, going on long time with CEPEP.
Right. The levy.
Mm-hmm. So just the levy.
The levy was basically the trigger to show that there was legal proceedings against the company because they could not have satisfied their debts, and a judgment was made and assets were being seized.
And then at that point, because we've heard statements that tend to indicate that there was some problem in terminating your services, what would have been the consequences for the company?
Company would have to answer that. If they decide to terminate us, then they would deal with Corporation Sole.
No, but it should be something in your contract, wouldn't it?
I could provide a letter of engagement. I could provide a copy to the committee.
Good morning, through the chair. In accordance with the engagement letter that Mr. Bridgell is referring to, there is no paragraph or clause in the letter that allows the company to terminate the agreement.
That's what I'm trying to get at. Okay? So that's a serious matter. Yes, that's a serious matter. How could we have a contract on engagement like that?
Okay, Member Karam.
Thank you very much, Mr. Chairman. Mr. Eddy, I think you indicated that you were having discussions with both persons who you owed in court and out of court. Have you set yourself, and do you have the ability to settle these payments, and have you set yourself a timeline by which you would want to take care of all these outstanding matters?
Remember, we actually would like to do it as soon as possible in terms of the timeline. We are sitting down and negotiating. So if we can get members, contractors to agree, we will settle those matters as soon as their contractors agree.
The other matter, I just want to ask Mr. Bridgelal, if you wouldn't mind. It seems as though from the discussions we had this morning that your major area of concern was the going concern aspect of the organization. But in your submission, I just wrote it down there, you said we had to do additional auditing tests. And what would those additional auditing tests be, and were you prevented from doing those as a result of not getting the information you required?
The additional tests on the going concern, we had to do these tests based on what we were requesting from the management, which was the assessment. We have to take a look at the assessment that management would make on the going concern of the company, the factors that were involved, how they're going to handle the outstanding claims, if they get a subvention for the government, how is it going to be used, like a proper plan. And that would have been the additional tests in which we would have to take a look at in order to make sure that the company is a going concern.
Did you get the impression, somebody listening to this conversation here at home,
yes,
might, even in their own mind, construe a conclusion that the reason why you had the breakdown in this communication and this relationship and trust and so on is possibly because in some organizations, companies do not want the truth to be told by the auditor. Did you find that was happening in this situation? To be exposed?
Well, we're the auditor. We have unrestricted access to all information.
No, I'm asking you in a sense whether you found yourself in this dichotomy to move forward because the company did not want you to have access to or to expose certain types of information that may impinge upon the future, not only going concern, but the reputation economy of the, not the economy of the country, but of the company.
Sorry, I can't answer that.
All right, you can. All right. Let me just ask the CEPEP. At all material times, and this has to do with your relationship with the corporation soul, has CEPEP been conducting its business in accordance, resolutely so, with the State Enterprises Performance Monitoring Manual?
So that is yes.
And then how come, if the answer is yes, I am seeing a letter before me dated the 28th of August, 2018, signed by the Minister of Finance, the corporation soul, indicating that there was a decision taken to appoint all members of the board to the Finance Committee, and he had to write advising that you were in contravention of the State Enterprises Performance Manual. Did that happen?
Answer. Yes, it did occur. That is why it was written it was corrected immediately. I believe at that time we were without a corp sec at that period. And that decision may have been taken by the chairman of the board at that time.
How did the corporation soul become aware of this?
Through a review of the minutes.
Of the minutes. Signed or unsigned?
Signed.
Member Antwine.
Thank you, Mr. Chairman.
Yes, Coburn. Thank you.
Thank you very much, Mr. Chairman. Mr. Eddy, I just want to get some clarification. The chairman in his opening remarks would have indicated there was a health sector initiative and you now have claims amounting to 160 million from contractors. When was CEPEP aware, when did you all become aware of that $160 million in claims?
I came into the company in 2016, and on coming into the company, probably a few months later, we started receiving letters from the lawyers, from one or two contractors from their lawyers as claims for payment for these amounts.
Okay. I also have a big concern, but you may not be able to deal with that, that over a 3-month period, we would have had contractors having claims of 160 million, which means the projects were probably more than that. How many contractors are we speaking about, and how many projects were done?
It's, I think it's 17 contractors. Oh yes, it is 1, 2, it's about 17.
Yes.
Roughly 17 contractors. And it's, I mean, the period of time and the amount of money did raise some concerns, which is why we felt that it was important to have the work valued. So hence the reason for the quantity surveyor.
Mr. Bridgel, just one question to you on this whole issue. The auditors, as auditors, you would have had a grave concern with respect to the one contractor who would have levied, and the whole growing concern issue arose. Was this 160 million, did that raise a red flag? Would that have been an issue of growing concern, or did you treat with this at all in your audit?
Oh, sorry, my apologies. Yeah. It would have formed part of the growing concern issues where the company would not have been able to pay the debts, and there were debts outstanding.
No, my concern is, based on your letter of resignation, your trigger was the levy that you read about in the newspaper, which didn't have a figure. I would have thought that this $160 million would have been a bigger trigger and should have caused that growing concern issue to be raised before.
The trigger was not the levy. There were 3 issues for the resignation, right?
No, sorry, Mr. Bridgel. In your letter, while you mentioned the 3 issues, your issue under not being provided with information was specific to that levy that was done, and it gave you cause for concern. My question is, it seems to me that this $160 million should have been a greater cause about the going concern and those questions that arose with respect to litigation. So I'm just asking whether that was factored in when you raised your issue about a going concern.
It would have formed part of the overall assessment we made that the company had these debts in which they needed to settle.
Thank you. Member Mark?
Yes, thank you, Mr. Chairman. Mr. Eddy, I wanted to ask whether the $1 million man has been sued by CEPEP.
Answer to that is that he was sent a pre-action protocol letter.
So we paid somebody $1 million, and we get to realize that we made an error. So we are now suing to retrieve that $1 million. Is that so?
No, I think I mean, as again, member, we did not specifically deal with that matter. We actually dealing because that was the person in charge of all these health sector initiative matters also. So it's on that basis that he was sent a pre-action protocol.
Okay. All right. Can you provide in writing what is the current litigation costs to your company between the period 2015 to the current time?
Certainly.
Could you also provide us with a list of all the cases, legal cases before the court, judgment debts that are outstanding, the names of the lawyers representing CEPEPs, the nature of the matter, and the status of these matters?
Certainly.
And then could you also provide us with I think Mr. Leons asked this question, if I would want to reiterate it, a list of all funds owed to contractors at this material time, and the names of those contractors. And I want to deal with safety and health of the workers. Now, in your submission, you did indicate to this committee that there were some 88 OSH violation reports against contractors. You did not specify the time frame or the time period in question. Was it between 2015 to maybe 2018? We didn't get that particular period that these violations took place as it relates to the CEPEP workers by contractors.
These would have been more recent.
Could you guys give us a time frame as to? Is there a report, Mr. Eddy, on this matter? Can you provide us with a copy of that report? And Mr. Eddy, through the chairman, would you be in a position to indicate what monitoring and evaluation mechanism on a regular basis is in place at CEPEP to ensure that these obligations by the contractors are met on a regular, daily basis? For example, personal protective equipment items for workers, boots, safety glasses, and face masks. I would imagine that you'll want to ensure that these workers are given gloves and apron and tools and screens and these sorts of things. What mechanism is there in place to ensure that these workers are in fact provided with these and you are made aware of those pieces of equipment on a regular basis? Do you have a special team of people who would monitor these contractors?
Remember, the answer to that is yes, and we are actually currently doing an audit. But we have safety officers who visit these contractors, as well as we have field officers who are there with them on a daily basis. And the safety officers will hold what we call toolbox meetings, will point out any safety violations, and those things are brought to the attention, but it's corrected. Those that can be corrected on site, and those that cannot, we will deal with it internally.
So how many OSH officers you have on your establishment now?
Currently, we have 3 officers, and we are actually just gotten approval to increase it because it's vast amount of contractors that we have to deal with.
Yeah. And how often do you receive, let's say, reports from these OSH officers so that you as a company would be aware that they are complying with the standards that you would have established consistent with the OSH law?
Okay. I receive the reports. There's a monthly report that goes to the board, but because I have a special connectivity to the health and safety of our staff and workers, so I certainly get it on a weekly basis.
Now these contractors under the OSH Act are compelled to provide these personal pieces of equipment at no cost to the workers, or are the workers called upon to dig into their shallow pockets to pay for this personal equipment? And if that is so, is that inconsistent with the OSH Act?
It's provided at no cost, member.
No cost. Are you satisfied from your assessment and evaluation thus far that these pieces of equipment are being provided to the workers who are engaged, 6,000, 5,000 workers on the CEPEP?
In most part, but part of the reason for the audit is that I want to be sure that the numbers actually prove what we're thinking and what we see. There are some issues. There are issues that we have to deal with on a daily basis, and it's also a culture thing, member. You find that you might find people not using the visor. They might be smoking a cigarette while they're doing. These are all culture and behaviors, and these are the things that we are trying to change.
Now, the question about these portable mobile toilet facilities.
Yes.
Are these also provided by the contractors, or do we have a situation where workers don't have that facility available to them, particularly female members of the workforce?
That is something that we actually, I think we spoke about it the last time we were here, and we've actually gone ahead now where we're looking at a pilot project of actually putting those facilities on a vehicle and having it available, particularly for the women that are out there doing work. So that is something that is currently under, we're actually implementing that at this point in time.
Right, and finally, Mr. Chairman, what is the penalty that would be invoked by CEPEP for blatant violation on the part of contractors who fail to meet these requirements as it relates to personal equipment for the employees employed by them on projects throughout the country, if they fail to do so?
Well, we take that very seriously, so that's why we have the officers going around and make sure it's being done, but ultimately that's a breach in the contract because it has to be provided, and for breaches you could be terminated.
The audit that you talked about, how soon you anticipate that would start and how soon it will be completed?
It should start next week, and it would probably take us about a month to get it completed. We want to look at all the tools and equipment and all the safety requirements, make sure that they're in place, but that's something that we are currently engaged in.
And maybe I'll ask the chairman, because, you know, CEPEP workers have been complaining to not only myself, but I'm sure to many members here, about the kind of challenges that they are faced with by these contractors. I think, Mr. Chairman, it would be a good thing that we take on board the possibility of some surprise visits to sites throughout the country so we can interact directly with the CEPEP workers, so we can get first-hand knowledge of whether their rights are being protected and defended by these contractors, or whether they are being breached and or violated against the laws of the country. So I think that is something I'd like to propose to the chairman so that we can probably look at that at some future time.
Remember, just one correction. They are not our workers. They are the contractor workers, which we are ensuring that they're actually doing. So it is almost what you're talking about is similar to what we do on a daily basis, is that we have to make sure that the contractor is providing what is required for his workers to perform at their optimal.
Yes, yes, thank you.
Thank you. And I gather that you monitor those contracts on an ongoing basis. Thank you. I have a couple questions. So, in your submission, when questioned about the procurement of a new external auditor, you stated that a request for proposals is currently being advertised for the provision of external auditing services. Is it safe to conclude that the external auditor has been contracted?
It's in the evaluation state, Chairman. The RFPs went out. It's being evaluated. I think by next week, a choice will be made, and then we will send out the relevant letter.
And could you let us know when that appointment has been made?
Certainly.
Thank you. Now, I would also like to get a copy of CEPEP's 2012-2015 strategic plan. And I would like to know what strategic objectives were achieved in the last strategic plan.
Will do, certainly.
In your submission, this is the submission of 5th of April, you stated that a request for proposals is currently being advertised for the development of a strategic plan. What period will that strategic plan cover?
We have, I don't know if it was, I think it was provided to the committee. It may not have been this one. We have an Arthur Lookjack report that had laid out some strategic objectives, which we have actually achieved. And I think we would have provided answers. There were some specific requests made, and we did provide answers on those achievements. So certainly it would be point forward, because that Arthur Lookjack plan actually provided a strategic direction for the company. I'm not sure if members have a copy of it, but if not, we can provide that also.
Thank you. And in your submission at Appendix F, you attached the company's draft fixed assets policy. When will this policy be finalized?
It's going for board approval at the next board meeting.
Very good, thanks. Any questions, anybody else?
Yeah, one question I'd like to ask Mr. Eddy. Mr. Eddy, we were told that some 24 contractors in April of 2019 attended a training workshop or several training workshops organized by CEPEP. Could you provide us, first of all, with what regions did these contractors or trainees come from? Where were these training workshops conducted? How were contractors chosen to attend these training workshops? And could you provide us with the names of these contractors who attended these workshops and the cost of these workshops? And maybe the final area you can probably clarify for us. And you can put all these things in writing, of course. You can give us a brief summary if you want, or if you would like. And what benefits would the CEPEP identified from these workshops conducted thus far? This is an area I'd like you to clarify first. As I said briefly, and you can probably give us it in writing.
Yeah. Remember, this was very specific to contractors who were exiting the program at the time. Exiting, but we felt that the workers, we had an agreement with the Ministry of Agriculture in terms of the cocoa industry, and we felt that at the time there was an opportunity to get people employed in that industry. So there was arrangements between ourselves and the cocoa company that it didn't cost us anything because they provided the training free of charge, and they provided the training so that on leaving CEPEP, and it was mostly in the rural areas and the areas that we would have cocoa plantations because they have a shortage of labor. And those individuals who were interested were asked to attend that training so that they can be trained and then pick up employment when their contractor's contract came to an end.
Okay. Well, would you be kind enough to provide those things?
Certainly.
Thank you. Thank you, Mr. Sherman.
Just as a follow-up, Mr. Eddy, in terms of the aspect of training, what you were really doing is more or less at the end of their contract, you were seeing whether they could move on to any other occupational areas. But with respect to your relationship with the contractors, the ones that are currently engaged by CEPEP, do you have any recommended training or have you engaged in any training plan with these contracted employees of any type?
And the answer to your question, member, is yes, we have a full slate of training that these contractors that we currently have on board will go through as part of their being in the incubator program. So when they exit, they would have had different types of training.
How often, if you could remember from memory, I mean, how often do you have that kind of training and through whom is it delivered?
Again, because of my timeline in the company, I'm not sure what would have taken place in the past. I could tell you what we plan to do going forward. And this training is something that we are starting to implement probably as early as the next 2 weeks, and it will be held in different areas. So we are now choosing centers to make it easy for the contractors to get to a center that is close to them. So in the north, in the south, central, so that we can begin the training. But there's a full training manual that we have sort of developed so that contractors can go through it.
Who will deliver it?
Both internal and external.
You mentioned just now when you were talking about the strategic plan and the points moving forward, you said that it was being done by ATA Lockjack. Is it by ATA or is it by the business school?
It was ATA Lockjack Business School. There was a plan that was done, full plan that was done going forward in 2016, I believe.
Okay, and what percentage of that would you say you would have accomplished?
I would say probably about, I think most of it, probably about 90% or more.
Vice Chair?
Just a quick clarification from the Corporate Secretary. Are you, in your experience, have you been submitting board minutes that are unsigned?
Through the chair, all signed copies of minutes up until March 2019 have been sent to the Minister of Rural Development and Local Government, as well as Minister of Finance.
And they have all been signed?
All signed, up until
Okay.
March 2019. The minutes from the April meeting have not yet been convened. Sorry, up until April 2019, as those minutes were just confirmed at the May meeting.
Okay.
Thank you. Now, before I invite closing comments, there's something I just would like to put on the record. As you know, we are a creature of the Constitution. We have a particular role and function to perform. Our powers are regulated under the standing orders and the Constitution and the law. Now, Chairman Ford is the chairman of a state enterprise, and this is a body that is in receipt of state funds. We have the power under the law to send for persons, papers, records, and the power to require witnesses to answer questions. And witnesses must answer all questions put to them. In fact, the refusal or failure to answer a question may be tantamount to obstruction of the committee and may be treated as a contempt and punished by the House after it has been reported to it. So, Chairman Ford is under a duty to assist us in our inquiry. I understand that this has been a somewhat emotional matter for him, but I am disappointed that he has chosen to absent himself from the inquiry this morning. And I certainly, while I'm not going to characterize his actions, I don't want this to be a precedent. So the committee is going to deliberate and consider what, if any, recommendations we will do in terms of dealing with this situation this morning. I leave it at that. I now invite closing comments from the officials of CEPEP, Hardy's, Chartered Accountants, the Ministry of Rural Development and Local Government, and the Ministry of Finance Investments Division.
Chairman, I would simply say that we remain ready and willing to answer any questions, whether written or verbal, that the committee has, and we remain available. That's my closing comments.
No closing comments, Chair. Thank you for having me here for Hardy's to give their side of the story.
Chair, we wish to thank you for the opportunity provided to us today to participate in this inquiry. We do hope that through our deliberations here today, we can now inform how the governance structures, systems, and procedures can be improved, and CEPEP can achieve its overall mission of building successful community business models, sustainable environmental projects, while ensuring equality, accountability, transparency, value for money, and efficient quality of services to our communities. Thank you.
We would like, the Ministry of Finance Investments Division would like to thank you for having us here this morning. We would also like to say that we would continue to work with CEPEP in the monitoring function, as well as the line ministry, and look forward to continued and improved compliance with the CEPEP.
Well, I would like to thank all of you for your contributions. Ladies and gentlemen, it would appear that this concludes our business today. I would like to declare the meeting suspended, and in closing, may I thank the company, the media, the viewing, and the listening audience. Thank you.